Welcome to the panel on public enforcement against surveillance pricing and wages. We have a remarkable panel here with us today. I'm Ted Mermin. I run a center of some kind here at the law school, and it is delightful to have with us three such accomplished enforcement people, personnel, and you will see what I mean. They will also be, and I want to emphasize Deirdre Mulligan, unfortunately, who does appear, spirit-like on your screen, and who is with us today is under the weather, alas, and not able to be here. But we will inflect our presentation with Deirdre's research. These folks are all with the states. And you'll hear a little about that, and we'll talk a little about that. So first, Stevie DeGroff, just to my right, is First Assistant Attorney General for the Technology and Privacy Protection Unit at the Colorado Department of Law, where, among other things, she has led the drafting and implementation of regulations implementing the Colorado Privacy Act. Prior to that, she was in private practice, advising companies on privacy and cybersecurity compliance, as well as issues in emerging technology. Chris D'Angelo, next one down, is, get this, Chief Deputy Attorney General for Economic Justice at the New York State Attorney General's office. Prior to joining the AG's office, Chris helped build and lead a little outfit called the Consumer Financial Protection Bureau. Eleanor Blume is Special Assistant Attorney General in the California Attorney General's office, where she leads the department's economic justice portfolio. Prior to that, Ellie was Special Assistant Attorney General in the California Attorney General's office, where she led the department's economic justice portfolio. In other words, Ellie has spanned two different administrations, which is, as a political appointee, which is nearly unheard of. So this collection of amazing people is who we get to work with today. Please do have your golf pencils and index cards ready to go. We will be taking your questions, of course. And I will encourage our panelists to have questions for each other. This is a conversation, and you know more about this than anyone else. So in 2024, as we've heard, the Federal Trade Commission launched a market study on surveillance pricing and released preliminary findings in January of 2025. And then the new administration effectively shelved that study. So how has that federal pullback affected your office's prioritization of this work? Is this a void the states and cities can fill? Is there a sense in each of your offices that it has been a time to step up? And what have you done?
I'm just gonna, okay. Go. I'll start. Well, first, thank you for having us and for those amazing introductions. I want to kind of like bring you with me whenever I have to do public speaking now as like my hype man. And then I'll say, and I think this probably stands for all of us, to the usual disclaimer that I'm speaking here on my own behalf and not that of my administration. So, yeah, I mean, I think that the at a high level, yes. I mean, I think the federal pullback in a lot of areas has created opportunities for state enforcers to increase their work where there are gaps. And I think that especially in not specifically surveillance pricing, but in kind of thinking about regulating technology more broadly, you saw states moving even prior to the most recent administration change. And so I think that kind of that confluence leads to a world where like this is an area where I think we are well situated to think about enforcement when the resources allow for it.
Sure. I would agree. First of all, thank you also for the invitation here. And this has been an incredible day. And it's been really inspiring to see so many thoughtful people talk about an issue that I think really has caught fire in an amazing way. I mean, credit to all the folks at the FTC who ran with this, credit to Zephyr for coining it, credit to everyone here for pushing it and lifting it up. But I think now we're in a place where we can actually see the fruits of that early labor, and people are willing to take action to put some real guardrails, if not stop these practices that I think resonate with people in a real way. In terms of states stepping up when the federal government goes away, I think across the board, New York has always felt the need to do cases of national importance that are important to New Yorkers, but important nationally. But I think even more so now, as we see the federal government stepping away, it's important for us to find opportunities to make sure that our own constituents and constituents around the country are not going without the protections that they're entitled to. And that's been true in the antitrust space, it's been true in the investor protection space, and it's true in the consumer space, and more particularly here with respect to surveillance pricing. We know that we can't rely on the federal government to step in and take the action that they need to.
Yeah, echoing what everybody has said, thank you, Ted, for welcoming us to this game show, and to all of us, for folks sticking with us through the afternoon into what is probably the drier part of the afternoon conversation after hearing from Sam about everything that New York is doing and the inspiration there, New York City is doing, and the inspiration there. While I largely agree with what Stevie and Chris have said, and we've spent a lot of time together and individually as states over the last year and change figuring out how and in what ways we are going to fill in that gap, I actually think that on surveillance pricing and on some of the issues in the consumer space more broadly, and pricing issues more broadly, our urgency around this is actually driven more by what we're seeing in the economy and the affordability crisis that Californians are experiencing, and that we think people are experiencing around the country too, where we have prices going up. I really appreciated the framing of the fog of wages. I think there's some very similar, on the other side, the fog of prices. There's a lot driving an increase in costs. And at the same time, wages are not keeping up with those costs. And so our urgency here is in part that we don't have our great partners from the Federal Trade Commission and US DOJ and the Consumer Financial Protection Bureau who had been really good enforcers and collaborators in trying to address these problems. And more significantly is trying to respond to what we see as being a real crisis point for people, where this part of what's going on the pricing side is driven by, unnatural isn't the right word, is driven by market forces that are not defined in a way that we would have previously expected, or that consumers would have expected, and maybe running up against our privacy laws and our competition laws and our consumer protection laws in new ways that require our attention.
So each of you in your state has taken on both some form of litigation in this area, as well as some form of legislation in this area. Could you give a sense of what you've undertaken, how it's gone, and what next steps might be, whether you've solved the problem or not?
Reverse this time.
I can start with that. We have not yet solved the problem. I appreciate the confidence, and maybe coming out of conversations like this, we will help to solve the problem, but we have not yet solved the problem. So I think, Ted, what you're referring to is that in January, California issued a set of investigative letters. We call it an investigative sweep across the market on surveillance pricing practices. We did those under the California Consumer Privacy Act, so highlighting the ways in which there may be privacy harms and violations of California's specific privacy laws in the ways that companies are collecting and using personal information of their consumers to set prices. That is all still very much an active investigation. We have not solved the problems there, but I think that what we have done by doing this investigative sweep and announcing it and being clear about our concerns and doing so on the heels of a settlement last year where we highlighted some similar issues around the use of data and the purpose limitation principle under California's privacy law. And Stacey's up there, who actually is the person in California who knows everything about this. So, to the extent that we get questions on this specifically, I'm going to point them to Stacey. But by highlighting the ways in which California's privacy laws could apply, I think that we've done some useful work in informing the market about what our expectations are and making sure that businesses understand what we're looking for. And one of the ways that we see a potential exacerbation of an affordability crisis through this misuse of data. I think that's the sharpest tool that we have in a way that is public and visible right now. It is also only one piece of all of this. We have our antitrust tools. The legislature enacted a new law last year on algorithmic pricing that requires at least two parties to it here in California, and there's some limitations on the ways in which that algorithm would be being used and be unlawful. So they're very useful, great new law. Where's Lee? They're great new law here in California. Only one other little piece of this, and then broadly, we have our unfair competition law that's very useful on point.
All right. How about you, Chris, in New York?
Sure. I think we're taking a multifaceted approach that includes legislation and enforcement. And I'll start by saying I would agree with what my New York partner here said, which is, while this is a very complex problem, if you let it be, it also has very simple solutions. And there's a bill in the New York legislature that our office supports called the One Fair Price Bill. It would ban surveillance pricing. We think that is the most straightforward, simple solution to the problem. But we're also not going to wait for that legislation. And so in the meantime, we have opened up investigations. It's public that we launched an investigation after Instacart there was a beautiful study that was published that demonstrated that Instacart was charging different prices, at least they say, on a test basis or an experimental basis. But we are currently actively investigating that particular conduct. We have other investigations that are ongoing of surveillance pricing generally, including surveillance pricing related to loyalty programs at different retailers. What we have found confidentially, but without referring to specific institutions, is that companies are engaged in a variety of schemes using personal data to hide the way in which they vary prices among different consumers, who might to themselves appear similarly situated, but are not getting the same prices. And they do it in a way that I think the fog of wages applied to the fog of pricing is it's very similar in the sense that you might find one individual getting a personalized price that is a 10% discount, and another getting a 25% discount, and a third person getting buy one, get one free. Your ability to compare those as an apples to apples comparison dissipates. And there was a conversation earlier about, well, is this a problem that's really about price increases as opposed to discounts? But when you see the practices, when you look under the hood, you see that what is called a discount is really a price increase to somebody else. And we're seeing that in real time as we conduct these investigations. It informs why we think a simple solution that bans the use of personal data to set prices is the only way to combat this problem. And we think it's the only way to do what is at the heart of, there was this discussion earlier about, is this a moral problem, or is this somehow the ultimate fruition of perfect price discovery. And actually, it stands in the way of price discovery, because when you have three similarly situated consumers getting three entirely different prices based on data that the company knows about them, but those individuals have no idea why they might be getting different prices, or that they're even getting different prices from the person sitting next to them, it completely stands in the way of a consumer to be able to do comparison shopping and for markets to actually reflect what the market clearing price should be. So even putting aside the moral piece of it, there's a very strong economic argument against allowing this kind of price variation by consumers.
So, Chris, you've got a law in New York State that requires this disclosure, all in capital letters, apparently. This price was set by an algorithm using your personal data. Does that solve the problem? Does it move the ball forward? Do you recommend this, at least as a first step for other states to consider?
It is a step forward, but I would not say it solves the problem, and I wouldn't think by virtue of the fact that we're supporting a bill now that would ban surveillance pricing, I think it's clear that we don't think it solves the problem. We will use that tool because it's a tool the legislature gave us until we get better tools. But that is not the way in which we're going to combat this issue.
Steve.
So I think that I'm going to say some similar things, but I want to kind of point out that I think that one of the reasons why all three of us are discussing various tools in a toolkit or different approaches to solving this problem kind of ties a little bit to the framework that Stephanie laid out on her panel of like there's different avenues or elements of surveillance pricing that cause consumer harm. And so figuring out the right solution to stop that particular avenue from causing harm can use different legal tools to do them, right? There's not one. I agree that like a ban is probably the simplest and most straightforward way to get there. But there's things that we can do now, and the things that we can do now are tailored to where we're seeing the harm. And so Colorado is very publicly, we were part of the Real Page lawsuit, and that's just straightforward antitrust theory, price fixing. It just happens to use an algorithm, and I think ironically, a lot of the pushback that we get, say, on Colorado's anti-discrimination and AI law is, well, can't you just use discrimination? Like, discrimination laws already apply. Why do you need a new law? And I think there are some times when you don't need a new law, and the law as written applies to the use of emerging technology or new technology and can be protective of consumers. Sometimes you need a new law to stop the harm from happening, because like catching them after the fact is not great. And sometimes you need a new law because there's these companies have found loopholes or ways to try to wiggle their way out of what's happening. And so I think there's a place for both, but there's definitely laws on the books, and antitrust is one of them, that I think can be really useful in this fight against surveillance pricing. We similarly, in Colorado to New York, have a law being proposed this session that would ban both surveillance pricing and surveillance wages. A bunch of amendments just came through, so I won't even try to tell you exactly what it does. I think there was like a committee meeting on it this morning. But broadly speaking, that's the direction that it's moving in. And then a lot of the work that I've been thinking about this through, the lens I've been thinking about this work through has been through privacy. And I think part of that is because we have a very strong privacy law in Colorado. We were the third to have one, so not California was the first, but we weren't far behind you. I also just, given my background and kind of where I come to this from, kind of personally strongly believe that abuses of data really lead to consumer harm. And like this kind of argument that like, oh, it's just data, like it didn't really hurt you at all if we take it from you. Like we just see all of the harm that flows from that. And so dealing with the data abuse, dealing with the misuse of the data, the miscollection of the data, the overcollection of the data can kind of chokehold some of the harms that we're seeing in surveillance pricing. So we have... we're kind of looking at it through this loyalty program lens. And we did a lot of work in our rulemaking in Colorado around the one line in the statute that said you can't discriminate between, basically you have to let people exercise their rights to delete their data, to opt out of its sale, to opt out of targeted advertising. And there's a kind of a vague thing that says unless it's part of a bona fide loyalty program that had no definition and there's no other words. And so there's a large section of our regulations that define what a bona fide loyalty program is, that limit that to a benefit to a consumer, and that make it very clear that if you're doing things with the data that have nothing to do with the loyalty program, that's not carved out. through this exception. And more importantly, you have to continue to provide the benefit to the consumer if they say, don't sell my data. There's, a recognition that sometimes you have to sell or share data to get the benefit. So if that's actually the case, if you truly have to tell Marriott that you flew on this flight from like that data has to be exchanged to get the discounted hotel rate, that's one thing. But if you're just collecting data, getting you in a loyalty program to collect data so you can then go sell that data, that sale benefits you, the business. It doesn't benefit the consumer. So you have to still honor their rights. And so that, again, is to Ellie's point, it's a slightly narrower way of thinking about it, but it is one of the ways that we know that loyalty programs are being abused to fuel surveillance pricing. And so that's we're looking at how do we enforce that part of our regulations and who are the people that are kind of abusing it. So that's, I don't know.
Can I?
Yeah, please, of course.
Something that Stevie just said there. I think, Stevie, your point about sometimes we need new laws, and sometimes also all the old laws we have are really great. Yeah. I think that's really important here. When we're talking about modern ways of going about fleecing consumers and modern ways of going about fleecing workers, like, it may be that we need some new laws, and I think new laws like banning algorithmic pricing, fantastic. There's we don't have one here in California, so don't go that deep into it. But I think that there are opportunities to take strong, clarified stances on as states or as cities to address specific practices that we see coming up. But we also have these incumbent laws like CCPA, which is not that old, but has been around a couple years, few years. 6 years. And also, thanks, Stacey. And our unfair competition law, which has been around for many decades, and our antitrust law. And then we see opportunities to build on top of it. So California has our Cartwright Act, which is our antitrust law in the state. Last year, we enacted a new law, AB 325, to specifically address the algorithmic inclusion on top of it. We have a great law in the Cartwright Act that we can use. We do use very successfully. We have our federal antitrust laws, like you referenced with RealPage in our ongoing litigation there. And then sometimes it can be really useful to identify those individual gaps. And I think the states have a lot of opportunity to learn from each other and build on that work to try to plug those holes.
So I want to follow up on this. There are some excellent bills pending, even in California. They've been introduced.
We have great laws.
Well, we have great bills.
We also have great bills in California. Many great bills in California.
We have somewhat fewer great laws, and that process thus far has kept us from being able to point to in California anywhere else a state law or otherwise banning surveillance pricing and wages. And so let's say just, for example, that they don't get through or they get limited in the way that Maryland's did and California's did last year before it just sort of died to just in-person shopping in a grocery store. And I think it might have been just the dairy aisle. Is there a way... you've mentioned a great suite of laws, Ellie, but I also, in the spirit of Sam Levine, who is known for this practice, let's go back to the archives, right? Let's look at what California law has to offer. And I know you can do this in New York because I was standing in a CVS and they were doing this to me, and I checked New York law at the time. So you have this too. But the Business and Professions Code 12024.2 says, it is unlawful at the time of sale of a commodity to charge an amount greater than the amount that is then advertised, posted, or quoted for that commodity. So that was not written with surveillance pricing in mind, but can we use something that old, or do we risk having a judge give you a raspberry and say, that's the 20th century?
So I'll just say that because we've discussed this, this came up earlier today about when you're in, I think Stephanie was talking about Walmart, you will be in the aisle and you'll see one price on the electronic price tag, and then you'll see a different price on your app, and then you'll see a different price if you're in the parking lot on your app versus on your phone in the app versus your computer at home. And I have heard through consumer complaints that this happens at all kinds of stores. In fact, some consumer complaints that we've gotten have talked about this happening where you'll go to the register and then it is a different price that gets charged to you, and luckily, and then the person catches it and then they'll fix it for you, right? The person at the register is not fighting with them over it. But like the system is so confused that they haven't even linked to what the register is charging when you scan the tag from all the different prices that people are saying. So I think, yes, that is definitely, we have something similar in Colorado, a law that we could use. You have to just kind of parse out some of the facts to get there, but it appears to be happening.
We would agree. You can absolutely enforce. I mean, what we're finding is that where surveillance pricing is happening most often isn't at the sort of physical brick and mortar retail store, but we have been doing some looking at, physical retail stores and whether or not they're charging prices consistent with their labels. And I would say I think those laws actually provide an excellent substantive justification for why we need to regulate surveillance pricing the way we're proposing to do it in New York. Because historically, that concept of one fair price was what motivated having these shelf label standards, and similarly also unit pricing requirements, right? This idea that you should be able to comparison shop. That actually is fundamental to the idea that you can comparison shop to do price discovery. This whole concept of price discovery is rooted in the idea that the consumer has transparency and open information to be able to make smart choices about whether or not they want to buy this good or that good, or buy this good from store A or from store B. And when you have this surveillance pricing going on, you undermine the competitive process that allows for that kind of price discovery. And it's actually what allows, it undermines competition as well as undermining fairness and transparency for the consumer. So yes, we should enforce those laws that have been on the books for a really long period of time. And we should also look to them because they provide precisely the substantive justification that what we're proposing to do is not at all new. It's actually the way we've always thought to do things, because it is the right way to allow for people to engage in the consumer marketplace in a fair and competitive way, where one market participant doesn't have an unfair amount of information relative to the other market participant. I will say another law that is on the books in New York, since we're talking about laws on the books, it's actually very, very new, is we had an update to our consumer law in New York State, which added, we used to be one of the few states that only had deception in its UDAP. We had a DAP. Now we have but now we have UDAP because it's got unfair, deceptive, and abusive acts and practices, which puts us in a position now to do something that I think most other states can't do. And in my view, abusiveness as it's defined, which for folks who are unfamiliar with it, you cannot take unfair advantage of an individual's inability to protect themselves from a series of prongs, one of which being, inability to protect themselves because they don't understand the risks of a particular transaction. Well, surveillance pricing is a situation where the consumer is completely unprepared to protect themselves from the particular risks of that transaction because they have no idea why the price was set differently for them than it was for someone else. And so, going to what someone else also said earlier about how do we get ahead of all the problems, I think updating our consumer laws for folks who have not adopted abusiveness in your states, to have these general principles of unfair and abusive that then can be applied to existing and future practices, I think is a good way to protect yourself and future-proof yourself to protect consumers.
Let me just ask something. At the risk of bleeding into our next panel, consider this a teaser to stay around. GBL 349 was amended for you, Chris,
I know.
but not for all of your friends at the private bar. What from the public prosecutor's point of view, what do you think about the need for a private right of action? We
fought really hard for a private right of action. And If I were in New York right now, the advocates in New York might be booing me right now. So we fought really hard for a private right of action. Unfortunately, between our legislature and our governor, it didn't end up in the final bill. We are grateful to have the additional authority, but we also think private rights of action are very important. We would love for our partners in the legal services communities and individuals themselves and the private bar to be able to enforce these laws as well. As Sam said earlier, we don't have enough resources to do all the work. There's no limit to the number of fraudsters out there fleecing consumers. And the only way we're going to really level the playing field is by giving consumers and individuals and small businesses, the ability to help us level that playing field with a private right of action.
Ellie? I can ask a different question.
You can ask a different question, or I can talk about how great and nimble our unfair competition laws. What we prefer.
Go ahead.
So to the prior point, before we got to the private right of action, I think this is exactly why it's so important to have strong state antitrust and consumer protection laws, like the Cartwright Act, like the Unfair Competition Law. We're delighted that our friends in New York now have a UDAP instead of just a DAP. I think it's really important that we have these flexible, iterative, long-standing laws that in California we have known for nearly 100 years that the Unfair Competition Law has the flexibility to be applied to all the innumerable schemes that man's imagination can come up to, or whatever the exact quote is from that case. Yeah. But the point being that these laws of general applicability were really designed and intended by the legislatures to be flexible and to respond to how the ways in which markets change. And also why we want to make sure that whenever we do come up with these very specific laws, whether it's on algorithmic pricing or similar, like plugging holes, that we're doing so in ways that are really quite targeted and not undermining that broader authority. But I think that we're always open to new laws. There are a lot of opportunities to try to plug those holes, and that we have really important, flexible consumer protection and antitrust laws here in the state that reach a lot of what we're trying to get to here.
So let me ask you this. We sit here at I almost have to ask this question, I suppose, in an academic institution. So as far as academic or similar research would go, what types of research would most help you in developing cases, in developing regulations, academic, practical, technical? Is there something missing that you have seen? And maybe, Stevie, we'll start with you, because I know this is an area that you are deeply steeped in, that you think, yeah, well, if we had this, or something that said that, or explored this area, then that would really make a difference. And I will, I'll say, everyone who is an academic, get off your phone right now and listen to what Stevie is about to say.
No pressure. I'll kind of two answers there. The first one is related, and then I'll get to the actual academic research question. But I think we in Colorado recently hired a technologist. And it's something that I'm a huge proponent of. I know the FTC and the CFPB and different federal organizations have had them. And I, for many a year, have just been really pushing for public interest technologists. And I just say that because I think that all of our offices will reap the benefits of having someone with technical knowledge in-house to help test the app and see what's actually happening before we send a subpoena, to figure out what questions we should be putting in our civil investigative demands, to get the GitHub repository and go through all the data and find the things that are in there to help us build the legal case. And that is not a skill set that exists in very many offices. And so I don't know if this is a research question, but if you have technologically gifted people in your academic institutions who want to come hang out in AG's offices, let us know, because it's a really valuable resource. And I think it's even if the laws are flexible enough, which I think we all agree, to apply to new technology, we still need to understand what the technology is doing to then apply the law to it. And so that's, the spiel I always give whenever I'm anywhere where I can maybe find someone to come help with that side of the work. In terms of the research, I mean, I don't know. I think that in some ways, a lot of the work that's being done, like this has been said today, but it's been really helpful, and it catches the public's eye. We read all those same things in our offices as well, and it helps give us good language and framing. In some ways, some of that work does a great job of alerting consumers in our states so that they then send complaints to our office and give us more information. So there's a positive feedback loop there. And I think that, I guess if I have to pick like one specific area of research that could be really beneficial, I think one of the battles that I've had to fight in thinking about this problem is two sides of this is just to give people discounts. They're just benefiting from it, right? And so I think any research that shows like actually they're not, like something empirical that gets to Chris's point of like, well, if you're just raising prices for everyone to then give them coupons, that's actually not a discount. Or yeah, maybe 60% of people benefited, but like, did they actually benefit? Like kind of pulling the hood up on that. And so I think anything empirical to kind of help us show this isn't actually benefiting consumers, this pricing practice is not helpful, would help, if not in a case, at least in arguing for these laws.
Yeah, I think the messaging point is really important for us, right? We do our best to talk about what we think the harms are to Californians, to Americans, where we think we are seeing an affordability crisis, where we are seeing competition harms and privacy harms and consumer protection harms. But having the well-structured, well-packaged research, like we saw out of the Groundwork Collaborative's report last year, other kinds of reporting that can really highlight and illustrate what the problem is, I think is focusing for me, for us, and helps us to tell a story about what's happening.
I would agree with all that. I would say, look, I would be a terrible academic, and I'm a simple person. I like straightforward things, and I like to sue people. And so the more your research can direct me to who I need to sue, the better. And so, but I mean that in a serious way, in that the Instacart report was incredibly helpful. The Uber and Lyft research is very helpful because it crystallizes a problem that resonates with real people, for which I can then think, do my tools apply to this particular circumstance? Mm-hmm. And how can I dig a little bit deeper? So it's almost like investigative journalism in some ways, the types of things that end up really being helpful from an enforcement perspective. And then the only other thing I would say is, like, I think we shouldn't be afraid to bring the fight to the folks on the other side using the language that they use. Like, I know there was a lot of discussion about, like, are we talking about just like, it absolutely is a moral problem, but that moral problem also can be talked about in economic terms, I think. And I don't think it's that hard to make that jump. I mean, I think what you have is here, sure, maybe there's efficiencies in some of these price settings, but their short-term efficiency is locally optimized to individual transactions. But that doesn't mean that we're creating long-term efficiencies and optimizing to what we want our global economic system to look like. And if every single person is at the red line, I mean, essentially what's happening is, the way these algorithms work, they keep everyone at the red line, just being barely able to afford the thing that they need. And if everyone's at the red line, no one's really prospering in the long run. And so there's a solid economic argument that's not moral about what the world is we want to create.
So I'm going to ask you in a minute for a question from that each of you would like to ask another member of the panel. I'm keeping myself removed from that list. But as you look at other jurisdictions, be they the second, first, argue one of the two greatest cities in the world, or other states, or indeed other countries. Are there other jurisdictions that have done some things in this area that inspire you, that make you think that's something we want to look at?
I will say my partners here are doing incredible work. I mean, some of it's so early stage, but I know that we're all working closely. I know Sam's team is doing some really thoughtful stuff, and I think you're going to see the fruits of it. I mean, we're coalescing around very similar answers to what is, I think, a problem of the moment. And I think the people you have represented here are part of a team of, activated states and localities who are all trying to figure out how to put pressure on this problem in very similar ways.
I agree with that. Good answer there. I think the states, we learn from each other a lot. And while it may be the case that in Sam's view, he has the very best attorney general in the country, I think we are, maybe in Chris's view too, and I think that I have the very best attorney general in the country, but I do think what we're so fortunate about right now is that we have a really tremendous group of states, the three of us here, and our colleagues around the country, who are really thinking about what the real problem is, not just kind of how we can get the best headline on something or the biggest number on something or whatever, but actually get to what is hurting people and how our tools can go fix that. And the states have a very robust, strong collaboration. I know that we looked at New York's laws as we were thinking about our investigative sweep. California and Colorado are in constant discussion on privacy, along with some of our other states across the country with similar laws. And we're just at a moment right now where I think the states are able to do phenomenal work that is getting, more importantly, to really effective outcomes for people. And we have a very strong iterative community for doing so.
First, I feel like I have to defend my attorney general, who is actually the best. Who's also the best attorney general. I know.
They're both even at second.
Next attorney.
But no, I want to really plus one both of those comments, and especially Ellie's comment that how collaboratively the states work together. And I'm kind of constantly surprised that people who aren't in this world don't know that. But we work very closely together. And I think that's where it strengthens the work that we do, the investigations that we do, the lawsuits that we bring, the settlements that get written. But I think it also just means that we're able to kind of have the conversation. I wish we could do it more often, but the conversations that you're having in this room today, we're able to kind of, for less time and less frequently, kind of get on a call and creatively think about the problem. And kind of, that's a bit of a brain trust. And so in some ways, it's I can't necessarily think of a law, but I can think of 5 people I would call who work at other offices that would talk to me about, what I mean? Some of them are up here with me. So I think there's a little bit of that, we're much greater than the sum of our very under-resourced parts.
I think Stevie just put that perfectly. That was great. It's, that isn't necessarily a jurisdiction or a set of laws. It's there are people who you could throw in a room to solve just about any problem right now. And I think that's a great thing.
So, having had time to think about it, what is one question you would ask another member of the panel? Each of you.
I was going to say, just to clarify, I'm clarifying the question here, clarifying the prompt. A question that we would ask another member of the panel that we would not be asking on that phone call to one of the 5 people that you would call to address the problem. Okay.
This is the previous question that we mentioned you were prepared for.
I'll ask a softball-ish question to Chris.
Okay.
So Colorado also recently got a U, but like in 2019, but we we did not get an A, the extra A. So I actually I'd love to hear more about the abusiveness standard and how you're thinking about that differently than unfairness.
I mean, I think both of them have a lot of merit to them, but I think one of the things that's great about abusiveness is I do think it really touches on a consistent consumer problem around information asymmetries or power dynamics, which is distinct from unfairness, which is an individual practice itself may be unfair. You're supposed to weigh the benefits to competition and to consumers, which can sometimes get people tortured. There's none of that in abusiveness. It's really a simple question of, has the offending party taken unreasonable advantage of some power dynamic or information asymmetry with the other party? That's a very powerful tool, and it's a fact pattern that repeats itself, I think, a lot. And so we are already starting to brainstorm about how we will use it. One thing that's unique is that the definition we have originated with the CFPB. There, they were limited to household goods and services delivered through financial services products. We can go beyond financial services, and we're not limited to household goods and services. We have, we can, look at small businesses, for example, as consumers. So there's a lot of opportunity to really think about some practices that have not gotten the attention that they needed because we only had deception before, and that even if we had unfairness, we wouldn't be able to tackle.
Right, I have one for Stevie. Maybe less of a softball, but you can duck it if you don't want. So we've focused this conversation on the pricing side, and earlier today we talked about wages. I'm curious how you think about ways that we could apply some of the same framework and the harms and the tools that we've been talking through to the wages side.
Okay, there we go. So I think I have all of my notes during the wages panel were kind of like, oh wait, could we use our wage theft law? Kind of trying to think through applying some of the laws that are already on the books in Colorado to the same problem and with the information that I learned today. And I think multiple people in this room have said to me at some point in time, either here or in other ways that I've met them, that consumers are workers and workers are consumers. And I think that is just very critically important and helps us as regulators kind of inform our thought and how we're thinking about the applicability of these things. To our point about collaboration, in Colorado at least, our worker protection team sits within consumer protection. It's not elsewhere. And so I think, again, even if they have a much deeper knowledge of the wage laws that exist than I do, but they sit 4 offices down from me, and we talk about things, and we work with each other, and we help brainstorm. And so I think that kind of cross-sharing will lead to being able to answer the question that you just asked. But yeah, I certainly think that it's the same principles are true. There's laws on the books that can apply. There may need to be new laws. I think that one of the things that's really could potentially be really powerful in that space is essentially I think that how do I say this? Consumer disclosures, I don't want to say don't matter, but they're more helpful to regulators often than consumers. But they are necessary in the worker space, because there's an even greater asymmetry of power. And so in thinking about the right tools to implement, I think that's an area where that may be more powerful necessarily than in the consumer space. But Lauren Gleason's going to get an email from me with lots of potential targets and comments when I get back.
So I have a question for Ellie. So we spent a lot of the time talking about consumer violations and how we would use our consumer laws. You mentioned your antitrust laws, and I'm curious if you've given some thought to the kinds of fact patterns you might tackle that are surveillance pricing related that have an antitrust component to them.
It's a a good question. That's a good question, and also like a lot of the thinking that we are doing right now. One of the things, last week was a great week in antitrust, and one of them, right? Our comms office has dubbed this hot antitrust spring. We are like all in on hot antitrust spring. So one of the decisions that we got, one of the decisions we got last week in the middle of all the really great decisions and things that were happening in antitrust was, came out of San Francisco Superior Court in our lawsuit here in California against Amazon. And we filed this case back in 2022. Amazon had filed what in California is called a motion for summary adjudication. It's a motion for summary judgment anywhere else. And the court found that Amazon's conduct, which it said that, it was essentially arguing that the California laws that we said applied did not apply. Court said, no, like all these antitrust laws apply to you. And we followed that decision with the filing of an unredacted motion for preliminary injunction. The great thing that happened by doing that was that we brought to light all of the ways in which Amazon was effectuating price fixing in the market. Amazon, largest online retailer, right, has all the reasons to use fancy algorithms and complicated ways of pricing and of targeting individual consumers. Also uses like the most analog ways of price fixing, right? It was like, make a phone call, send an email. I guess that's not the most analog way, but like, the more analog ways. And so this is a little discursive, but to say, like, we are seeing, I think, we're seeing algorithms move into parts of the market that don't need them. We're also seeing like our tech companies rely on some fairly old school ways of going about engaging in price fixing behavior. And so we've been giving a lot of thought to like where when you have all the information and a willingness to be quite reckless, we might see companies like, inadvertently or intentionally trip into maybe misusing all this information they have, even if that is kind of coming out in ways that look a little more like making a phone call, rather than just publishing something. And so I don't have targets, so we can talk about it here, right? But we've been doing a lot of thinking about ways that the companies, whether first-party only or third-party data that might be more covered by our new laws, or the use of the use of a competitor's data might be sort of like sucked up, and then like, oh, whoops, we happen to keep or intentionally we are using it, whether that's publishing it to set prices in agriculture markets or housing markets, or that is using it in order to make the phone calls to a competitor. And I think the algorithms create opportunity for essentially like whitewashing data, and potentially like whitewashing competitors' data, and then concealing unless we have adequate technologist resources at a state level, like concealing the ways in which like all those inputs are then informing what a company goes about trying to effectuate in the market.
Chris, do you have anything you want to add? People have had an opportunity to talk about the focus on wages, which, interesting to hear how other offices are taking these same insights that we've heard about for pricing and focusing on wages, and also if antitrust has informed your own thinking about this.
Yeah, I mean, I think those two things are absolutely present in the way we're thinking about this problem. I mean, we started with it as a pure pricing problem, but as others have talked about here, the same tactics are being used to set wages in a way that's using people's personal data to their disadvantage and in ways that they can't possibly understand. And so I think, we are absolutely, keeping our eyes on where we might be able to make some progress in that space as well. I think, the problem of algorithmic pricing in the context of antitrust, I don't even think it's that complicated, right? The more data you have, the more pricing the bigger you are, the more pricing power you have, and then you combine that with your ability to set algorithmic pricing with personalized data. There's no competition to begin with, and now you can just create that fog at which allows you to charge whatever price you can get away with, essentially.
So let me ask what may be our final question, if you take it, and run with it. And here I am channeling Doha, Meki. This comes direct from Doha. Wherever you are, Doha, hello. If there is one thing practitioners, businesses, lawmakers, or consumers in this room should do differently in the next 6 months because of this conversation, what is it?
All right, I'm gonna give an answer to give you guys time to think. I'll talk slowly for a second. Okay. Be fearless, right? I think that one of the things that we've talked about up here is that there are things that we can do today. We don't have to wait for a new law. There are things that consumers can do today. We've heard about the power of workers' voices, the power of consumers' voices. That moves the needle, even if only a little bit. Sam got us all fired up talking about the little engine that could in New York. like people who are really passionate about this, who really care, coming together, make change, and you win ultimately in the end. And so I just think that this, in some ways, the conversation, not just our panel conversation, but the conference so far today, shows all these kind of horrible, scary, disembodied algorithms in the sky harming us, and that can feel really disempowering. But I just think I kind of walk away thinking there's so much we can already do today, even if it doesn't fix the problem. So be fearless and go do that one thing, and collectively that will fix the problem.
I like that. That's perfect. No notes. Be fearless. I also say don't be afraid of the algorithm. Yeah. It is just another thing. It is just another business tool, technology tool. We've got great laws. Maybe we'll get more laws. But don't be so convinced that this is something for the tech guys, or something we can't possibly understand. We understand consumer protection. We understand antitrust. We understand protecting people's privacy. We understand fighting for workers and consumers. Go do that. Don't be afraid of the algorithm on the other side.
Again, no notes for both. So, be fearless. It's not that complicated. And go tell everybody about it. That's exactly, when people learn about how simple it truly is, and that you're getting charged one price and they're getting charged another, and you don't know why, it's not complicated. Don't be fearless about talking about it, and just make sure everyone knows, because it's appalling when you are confronted with that fact. And if we keep telling everybody, we're both gonna act on it, and we're gonna get more people to act on it, and we'll jump on this momentum that we have now to try to solve this problem.
All right, please. This has never happened in the history, certainly of academia. We have a minute left and we're stopping. Please join me in thanking this panel of luminaries.